Ladies and gentlemen, Happy New Year and welcome once more to um, another presentation on immigration issues in Denmark, done by my humble self. And I'm doing this presentation on behalf of immigration law experts for Denmark and the EU, and we've been around for quite a while in Denmark, handling cases on immigration issues and giving advice to people who have immigration related issues. So, immigration law experts in Denmark and the EU is a consultancy on immigration issues, and I, for one, have 5 years experience handling immigration issues in Denmark. And you can find more information on our Facebook page, where this video is certainly posted. And this video is also going to be posted on my personal channel on YouTube. That said, many things have been happening in relation to immigration issues in Denmark. Many things are going to happen, and so for a while we have not made any presentation on immigration issues in Denmark. So I thought it wise to make a presentation to usher us into the new year, and hopefully to have a situation where people become more aware of immigration issues in Denmark, and by so doing, they will have less immigration problems in Denmark, hopefully. So this presentation is going to be about an overview of current Danish immigration rules and the future outlook. So we're going to try to present an overview of existing immigration rules in Denmark, and we are also going to try to give an outlook of new rules that are likely going to be put in place during the course of this year. Once more, I might have to present myself. I've done it several times during previous video presentations, but I think it's still okay to do it once more because some people don't know who I am, and it's our duty to let the public be aware of our competencies with regards to immigration issues. In particular, if we present ourselves to the public as experts on immigration issues. So yes, my name is Divine Jinor. I'm a senior legal advisor for immigration law experts for Denmark and the EU. I have 5 years experience handling immigration issues in Denmark as a legal advisor. I have a master's degree in European Union law from from Lund University in Sweden. I have a master's in law, as an LLM in law and information technology from Stockholm University in Sweden, and I have a bachelor's degree in law from my home country, with a specialization in common law and optional courses in civil law. So you can find our more information about us from our website, from our Facebook page, which is Immigration Law Experts, facebook.com/immigration law experts in Denmark. There you can also find email information and telephone information on how to contact us, and you can also send us messages through our Facebook page. This presentation, as you might have guessed, will be very long if we have to do all of it at a go. So I have decided to split the presentation into two parts. This part of the presentation is a recorded presentation, and the second part of the presentation that we will do subsequently, probably in a couple of days, would be done live. So this presentation will be done in two parts, like I said. Part one will give you an overview of our services, and would like to present some of our success stories for very complex immigration cases. And we thought it wise and very important also to present our own criticism against Danish immigration authorities and related administrative organs. These are organs who carry out activities that are related to immigration issues. So our presentation for today will be based on a presentation to the public of our services, and we're going to present some of our success stories for very complex cases, and we're going to give our own version of criticism against some of the activities of the Danish immigration authorities and related administrative organs. The second part of the presentation, which will be done subsequently and you'll be informed about it, just make sure you like our Facebook page so that you like and follow our Facebook page so that you get informed anytime we are doing a presentation. But I promise you this second part of the presentation would come in a few days time after we must have posted this first part of the presentation. So the second part of the presentation would be focused on very important information on immigration issues, and this would include the do's and the do nots. So things you have to do to make sure your residence in Denmark is hitch free, and things that you do not have to do. So we call those do nots. And then we'll also present new immigration rules, because some new rules have been implemented recently, and we need to give some explanation on these new rules. We'll also give an outlook on upcoming immigration rules. So the coalition parties in the parliament have made some agreements that they'll implement some new rules in the course of 2020. So we are going to try to give an outlook of what these new rules, potential new rules, will look like. We also like to talk about exceptional grounds, because we think they are very, very important. Exceptional grounds are like things that change the game on immigration issues. When everything else goes wrong, exceptional grounds can save the situation. So we're going to see some things about exceptional grounds. We're going to see some things about permanent residence for the 8-year rule and the 4 years rule. You know, it's possible to get permanent residence after 4 years if you fulfill all the requirements, and 8 years if you fulfill the compulsory requirements and 2 optional requirements. But if you fulfill all of them, you can get the permanent residence in 4 years. We're going to talk about that. We're going to talk about permanent residence for minors. That's permanent residence that can be acquired between 18 and 19 years for young people who have spent a substantial part of their lives in Denmark and who are not yet Danish citizens or who do not yet have the permanent residence. We're going to talk about permanent residence under EU rules because that's it's a totally different ball game. Permanent residence under EU rules. We're going to talk about salient issues related to the green card and other work permits like the pay limit scheme and authorization for medical doctors and dentists and things like that. And in the course of doing this, we're also going to do a presentation on things related to their dependents. We're going to talk about family reunification under Danish rules. We are going to talk about EU immigration issues that includes residence cards for non-EU family members of EU citizens who have established a genuine and effective residence in Denmark, and registration certificates for EU citizens who have established themselves in Denmark. We're going to talk about that. We're going to talk about student permits, salient issues, not everything, important issues on student residence permits, and also things related to their dependents. We're going to talk about important things related to Danish citizenship. We're going to talk about important issues related to asylum cases. We're going to talk about important issues related to short stay visas, and this is very important because the countries that are parties to the Schengen agreement have agreed to modify the rules for Schengen visas come, I think it's February 2020. So some new issues have come up in relation to short stay visas. And we're going to talk about divorce related issues for those who are immigrants. So divorce related issues are like how a divorce situation can affect the residence permit of a foreigner who is married to somebody who is settled in Denmark or something like that. And then we also give general legal advice. So we'll say some things briefly on the general legal advice, like advice on criminal cases, on family law, on business startups, real estate, labor law, etc., etc. So most of these things we are going to look at the most important issues and talk about them. So like I said, this presentation is in two parts. So we're going to start with the first part, which will be the focus for our presentation for this part of this first part of the video presentation. Video presentations, because it's going to be in two parts. So we're going to start with some of our success stories, and in connection to that, I would like to say that sometimes we win our cases and sometimes we lose. That's the way it is in the game, but we fight for our clients to the end. And we even encourage our clients not to give up. We encourage them to fight to the end, because when you give up along the way, you might miss the chance to get justice served on your behalf. So, in general, we win most of our cases. That is a fact. I cannot give you the exact statistics, but most of our cases end up with positive decisions, especially in situations where the clients abide to our strategies and fully respect our instructions. This is very important, because then sometimes when you're handling the case for a client, then they have their own ideas and then they get advice from friends. They try to see other experts and they're confused, and they follow multiple strategies. In situations like that, it's hard for us to enforce our strategy for the client, and that might affect the case. But for clients who abide to our strategies and fully respect our instructions, in most cases, they get positive decisions. Sometimes clients are very pessimistic, and sometimes they even think that the kind of problems they have cannot be solved. And in some cases, such clients give up and will not accept to fight to the end. We do our best to encourage them, but at the end of the day, it's the client who has the choice. And if they don't want to proceed with their case or they want to go to somewhere else, it's their choice. But we always do our best to encourage them to be patient, because many of these immigration issues are very complex, and we have to use complex strategies to tackle them. Um, we have many success stories, many success stories that I personally, as an immigration advisor, has been involved with. But it's not possible for us to present all of them here, so I just chose 10 of them. I don't know if they're the top 10, or because we have really many complex cases, but I just chose 10 of them to present to the public, because then many times when we have calls from clients, sometimes they try to know if you get positive results, but we tell them this thing is not mathematics, it's not rocket science. You cannot say 1 plus 1 equals to 2. So we cannot give you any guarantee that we are going to win the case. All we do is our best. So the best we can do to tell the public that we are competent and we can handle very complex cases, and we have handled many complex cases and won, is to present some of our success stories to the public. And trust me, they're very interesting cases. Um, Case number one is a case where a Dane married to a foreign lady. Um, the foreign lady applied for family unification in Denmark with her husband, and she made the application together with her 15 years old daughter that she traveled to Denmark with from abroad. Her mother's, the woman's application was granted, but that of her daughter was refused, and she was asked to leave Denmark, based among other things on the fact that she could no longer integrate in Denmark and would be better off in her home country. So, based on the exceptional grounds we used in the case, the Immigration Appeals Board allowed her to stay in Denmark during the process and referred the case back to the Danish Immigration Service to take the exceptional grounds we have cited into consideration before making a new decision. That is reference case number one and a success, one of our success stories. So, success story number two, the application for family reunification for a 13 years old boy to reunite with his foreign mother, married to a foreign citizen who acquired permanent residence in Denmark on the basis of his status as a refugee, was refused by the Danish Immigration Service. So, the application for this 13 years old boy to reunite with the mother who is married to somebody who got permanent residence in Denmark as a refugee was refused. And again, the grounds given for the refusal was that the child could no longer integrate in Denmark. And in the best interest of the child, the Danish immigration thought he will be better off in his home country. The child was asked to leave Denmark. An application was made by us on behalf of the family for the case to be reopened. And this application was refused by the Danish Immigration Service, and the child was still requested to leave Denmark immediately. We advised the parents to send the child not to send the child back pending a decision from the appeals board, to which we submitted an appeal against the decisions from the Danish Immigration Service. In the case, we argued that the refusal of family reunification with his mother and his stepfather and the request for the child to leave Denmark was made without existing exceptional factors being taken into consideration. Also, we argued that there was gross violation of the Danish Administration Act, because the Danish Immigration Service did not give our clients the right to be heard. So the right to be heard in Denmark in Danish is called partshøring. So before a negative decision is made in a case, administration-related case, including immigration cases, it is mandatory that the administrative authority should give the opportunity for the party to be heard. In this case, the Danish Immigration Service made a decision without giving the opportunity for the 13-year-old child and her parents to give their comments before a negative decision was made on their behalf, made in his case. So that is one of the grounds we use for the appeal. Furthermore, we said the decision in this case, in our judgment, was a gross violation of Denmark's international obligations, as well as its obligations under EU rules. I mean, the stepfather was a refugee and could not return to his home country, and they had other children who were born in Denmark and had built a strong connection to Denmark. So asking this child to return to his home country was tantamount to asking the person who had political issues and the risk of being persecuted in his home country to return to his home country with his family and his wife if they wanted to be together with this 13-year-old stepson. So this was, in our judgment, a gross violation of Denmark's international obligations, as well as its obligations under EU rules. In this case, the Immigration Appeals Board overturned the decision and decided that the child should be in Denmark pending the final decision from the Appeals Board. And we believe that the same exceptional grounds will lead to a positive final decision in the child's case, and the child will eventually live in Denmark permanently together with his mother and stepfather. So a third case that we consider as a success story is the case in which a foreign national had his application for family reunification in Denmark under EU rules with his wife, who is a citizen of an EU member state, refused, and the re-entry ban he previously had was increased for 2 years. The refusal of his application was based on the grounds, among other things, that he had an ongoing re-entry ban, and his previous conviction in Denmark for illegal work made him a danger to public policy in Denmark. We applied for the case to be reopened, arguing, among other things, that his previous conviction did not meet the standards for him to be considered as a danger to public policy in Denmark, and that given the circumstances of the case, his re-entry ban was not applicable. The case was reopened and our client was granted the residence card under EU rules. The fourth success story or case we would like to present to you is a case in which a foreign national who was in Denmark under the green card scheme applied for permanent residence. This application, in the course of the processing of the application, new rules came into force, changing the income requirements for the extensions under the green card scheme. He was given a negative decision and was asked to leave Denmark because he did not fulfill the new requirements for the extension of his green card. The Immigration Appeals Board confirmed he had to leave Denmark pending the appeal decision, and he eventually left Denmark. His dependent wife and 2 children had their extension applications refused subsequently and were also asked to leave Denmark. Based on exceptional grounds that we used in the case, the Immigration Appeals Board allowed the wife and the children to be in Denmark during the appeal process. But at the end of the appeal process, they were eventually refused. At the end of the appeal process, the decision from Syria was upheld, and the wife and the 2 kids were also asked to leave Denmark. We assisted the wife and the children to make new applications based on their strong connections to Denmark and other exceptional grounds. The applications were granted. Subsequently, we also assisted the husband, who was already out of Denmark, to make an application for family reunification with his wife and children based on exceptional grounds. And on the basis of this application, he got a new residence permit, and the family has been reunited in Denmark. Another success story, like I said, we have many of them, but I just selected a couple of them because of time constraints. So this is the 5th success story I was personally involved with. In this case, a Danish citizen who got permanent residence while under the green card scheme and subsequently acquired Danish citizenship was in a situation in which the Agency for International Recruitment and Integration, that SIRI, is the authority that deals with the green card cases related to the green card scheme and the establishment card scheme and student permits and other work permits. So Siri refused the extension application for her dependent husband, and he was asked to leave Denmark based on the fact that she had become a Danish citizen and green card rules were no longer applicable for the extension application. Using arguments on exceptional grounds, we were able to sustain his stay in Denmark and his right to work, and eventually he got the residence permit based on Danish family reunification rules and not the green card. You remember, so family reunification under Danish immigration rules are different from applications made by dependents under things like the green card and the establishment card and student permits, etc. So he eventually got a residence permit based on Danish family reunification rules without leaving Denmark and without losing his right to work during the entire process based on the strategies that we used. And then the sixth success story is this case in which a foreign national who had left Denmark returned after a while and applied for family reunification in Denmark under EU rules with his wife, who is a citizen of an EU member state. Unknown to him, he got a refusal letter sent to his e-box that he had never used prior to leaving Denmark, because then he left Denmark at the time when the e-box was newly introduced. So he had never used the e-box before, but the decision was sent to his e-box. Unknown to him that a decision had been made in his case, he went personally to the EU Immigration Office and requested to have information on the status of his case. And he was told that a refusal letter had been sent to him months ago and that he was currently illegal in Denmark. Scared that the police might be called and that he might get arrested, he ran away and left his passport behind. Subsequently, he contacted us and we applied for the case to be reopened based on the fact that he could not have known that he had been given a refusal by the EU Immigration Service. So we applied for the case to be reopened based on the fact that it was not possible that he could have known that he had been given a negative decision in his case. The application for the case to be reopened was granted, and we also used legal arguments and strategies to recover his passport that had been sent to the Danish police. His application was subsequently successful and he was granted the residence card under EU rules. We have this seventh case in which a foreign citizen who was under the establishment card scheme and whose ex-wife and daughter had acquired Danish citizenship applied for family reunification with his daughter. The application was refused and he was asked to leave Denmark. The refusal was based on the fact that he did not have sufficient visitation time with his daughter. In this case, he was never given any opportunity to be heard in the case. I'm talking about the part hearing thing I talked about before. The right to be heard before a negative decision is made in your case. And the fact that he had applied to the authorities for more time with his kid, and that the authorities, as currently the authorities I'm talking about is the Common, the Agency for Family Law, and even the courts, because his case was being handled by these three authorities. The Common, the Agency for Family Law, handling custody related issues for children, and the Common supervising the visitation issues for children who have parents who are not married or who do not share a common home. And then you also have the court that made a temporary decision in the case in relation to the custody of the child. So all this information from these authorities were unknown to the Danish Immigration Service at the time they made the decision. And remember, he was not given the right to be heard. The Immigration Appeals Board upheld the decision from the Danish Immigration Service that our client should leave Denmark pending the final decision in the case. We advised our client that leaving Denmark would be equal to giving up his rights to be with his daughter. He decided to stay and was recently arrested by the police for being illegal in Denmark. In collaboration with a Danish lawyer, because if you remember right, I said I'm a legal advisor. I'm not a lawyer in Denmark. There's a difference between a legal advisor and a lawyer, because to be a lawyer you have to go through the process to be a member of the core of lawyers in a particular country. So lawyers and legal advisors are law experts, but lawyers have been called to practice at the core of lawyers in a particular country. So there are some things that are reserved only for lawyers. For example, to defend people in court, to represent people in court, to in relation to things like divorce cases, and to sign deeds and some other things. But many other things related to administrative issues are things that legal advisors are competent to do, provided they are given the power of attorney. So that is the area in which we operate as legal advisors, and we are competent to handle all types of administrative issues, provided they are not taken to court. So we collaborate with competent lawyers when we have cases going to court. So in this case, where our client was arrested, we got into contact with one of our lawyers with whom we collaborate, and we gave her all the relevant documents in the case before the court hearing that took place shortly after his arrest. So on behalf of our client, this lawyer presented strong evidence in court that he should be released, and the court made a decision that he should be released and that he could continue to visit his daughter. We have applied for the immigration case to be reopened. That is the case related to his application for family reunification with his daughter in Denmark. And we rely on the powerful ruling from the European Court of Justice that it would be a violation of EU rules to ask the father of a Danish child to leave Denmark and eventually force that child to travel out of the EU just because that child wants to see her father. It's a landmark judgment from the European Court of Justice. And that is the core of our argument in this case. On the same grounds, we have appealed against a decision to give him a 2 years re-entry ban to Denmark. And we are very optimistic that the outcome of this case will be positive. Our eighth success story is a case where a foreign student had his studies suspended by his university for plagiarism. So it's very common, it happens all the time to foreign students, to EU students, to Danish students who get sanctioned and suspended for a semester or a couple of semesters because of plagiarism. The university informs Siri, and Siri made a decision that our client had to leave Denmark. We advised our client to leave Denmark and assisted him to make a new application to continue his studies in Denmark after the suspension period from the university had elapsed. The application was successful, and the student returned to Denmark to complete his studies. Wow. And then our ninth success story is a case in which a foreign student was absent from her university due to sickness, and the university informed Siri that she was no longer an active student. Siri requested for comments from her to explain why she thinks her student residence permit should not be revoked. Under normal circumstances, she was supposed to have applied for an exemption to suspend her studies and return to her home country for treatment with the possibility to return to her university after getting healed. But in this case, on behalf of our client, we used legal arguments and medical records to prove that it would have been very risky for our client to travel to her home country given the nature of her sickness, and forcing her to do so would have been an inhuman and degrading treatment. She was allowed by Siri to continue her studies in Denmark after her sickness. And then the last success story we're going to talk about is something not really related to immigration issues because, like I said, we have competencies to give general legal advice, and from time to time we handle other legal issues not strictly related to immigration issues. But in this case, one of our clients was wrongfully terminated by his employer after he received a refusal of his application for permanent residence under EU rules, and was asked to leave Denmark if he did not submit an appeal within the deadline. We assisted our client to submit the appeal within the deadline, and he was allowed to be in Denmark during the appeal process. Nevertheless, our client was wrongfully terminated from his employment with an argument that he did not have the right to work in Denmark. On behalf of our client, we provided arguments to show that he still had the right to work in Denmark during the appeal process. And based on our arguments, he was reinstated to his employment position. So, ladies and gentlemen, these are some of our success stories, and there are many, many, many more success stories and many more complex cases and normal cases. But when you look at the nature of Danish immigration issues, things that people take lightly become very complex. So, one of the advice we always give to people is that whenever you receive a letter from the immigration to give your comments in relation to your case, know that it is a signal that you might have a negative decision in that case, because they have seen something that might lead to a negative decision and they're asking you to present your comments, and that is your last chance. So our advice is, when you have a letter like that, please don't try to handle it on your own. It might be a do or die situation. You can contact us, or you can contact any other immigration law experts that you know can do a good job. But we are confident that we can assist you with situations like that. Another thing that is good for people who have immigration related status, immigration related issues, and usually we say that if you are not a Danish citizen and all your kids and your wife and all your kids and your spouses, if the entire family is not made up of people who have Danish citizenship or EU citizenship, then know that you have potential immigration issues. So what we advise is that from time to time, people can come to us to do assessments on their immigration status, because sometimes you have potential time bombs that are unknown to the clients, that at the appropriate time come as a surprise to them and create a disastrous situation for their uh, immigration status in Denmark. Um, we are currently working on many complex cases. We have many other complex cases we have worked on, and for the sake of time, we cannot present all of them to you, but we hope that in the future we will do so. And we also hope that you got some lessons from the many different complex cases that we presented as our success stories. So the last part of this, the last section in this part of this first part of our video presentation is related to our criticisms against Danish immigration authorities and related administrative organs. So you will know that for the time being, Danish immigration issues are handled, not taking into consideration the appeal organs. Danish immigration issues are handled by the Danish Immigration Service, which handles asylum cases, cases for permanent residence and family reunification, and the Agency for International Recruitment and Integration, called SIRI, which handles all EU-related cases and cases for work permits and a green card, pay limit scheme, establishment card, and students and au pair cases. So these are the two principal authorities that handle Danish immigration issues. And then in addition to that, you have the Immigration Appeals Board for appeals against ordinary decisions from either the Danish Immigration Service or SIRI. You have the appeals board that deals with cases deals with asylum cases that have been refused by the Danish Immigration Service. We are not involved in that because the appeals in such cases are in the form of a court session in the presence of a judge and lawyers on both sides. So we are not competent to handle appeals on asylum cases, but we can give advice related to asylum cases, but we cannot handle appeals. So the three major immigration authorities I'm talking about is the Danish Immigration Service, the Agency for International Recruitment and Integration, SIRI, and the Immigration Appeals Board. And then the other organs are referred to as authorities that carry out activities related to immigration issues. And in this particular case, I'm referring to the Agency for Family Law, known in Danish as Familieretshuset, which handles family law issues like marriages and custody issues. So these are the authorities I'm going to talk about. So I will start with our criticisms against the Danish Immigration Service. It's very hard for us to know where to channel our complaints to, because then it's like a ping pong when we send complaints about the way some of the immigration authorities are handling some cases. So we know that when it comes to excessive delays in handling of cases, we can complain to the Ministry of Immigration and Integration. But these are not the only issues. There are many issues that we think are done in the wrong way by the immigration authorities, but it's not very clear to whom we have to send the complaint. So I'm using this medium to send the complaints to the powers that be, to know that we have some things that we think are not okay with some of the Danish immigration authorities. So I'm starting with criticisms against the Danish Immigration Service. These criticisms are based on our judgment. We might be wrong, but to the best of my ability, I think the criticisms are correct. The first criticism against the Danish Immigration Service is that in some cases they have excessively long case handling times, especially for family unification, and this to us is without any lawful justification. We are also criticizing them for the fact that sometimes they refuse to assess strong attachments to Denmark for those whose immigration cases have been refused, or for those who are to be deported. And we think this is a violation of the Danish Aliens Act and Denmark's international obligations. We are also criticizing the Danish Immigration Service in that for some cases they don't respect the rulings from the European Court of Justice in relation to family unification for parents of Danish citizens who are non-Danish citizens or who are not citizens from any other EU country. So these people who are neither EU citizens nor citizens of Denmark are referred to as third country nationals. So in our experience, the Danish Immigration Service in some cases does not respect a landmark ruling from the European Court of Justice in relation to family unification for parents, third country national parents of Danish citizens. Another criticism also is that in some cases, the Danish Immigration Service does not take into consideration exceptional grounds that should be applicable in the cases. Another criticism from us is that in some cases, decisions are made by the Danish Immigration Service without giving the opportunity for the parties to be heard. The parts hearing thing I'm talking about. We have lots of cases like that where decisions were made without the parties being given the opportunity to give their comments before a negative decision is made. Before a negative decision is made in such cases. We also criticize them that they take excessively long periods to make decisions for case reopening applications, and we think this is a violation of a standard practice and guidelines that come from the ministry and also comments from the ombudsman, which in our judgment indicates that decisions for case reopening applications should be made within a month from the time of the application. That is our judgment, and that is what we could find based on our research, that the standard practice for case reopening applications is such that the decision to reopen the cases or not should be made within 1 month from the date of the application. But we have situations where the Danish Immigration Service is indicating that they will take 8 months to decide if they will reopen the case, and in this particular case is a case related to an application for permanent residence that was refused. So they informed our client that they will take 8 months to decide if the case will be reopened, and they will take further 8 months to make a new decision in the case. 16 months in total. I don't think that is a normal practice, and I think it's something that the Danish Immigration Service should be criticized for. We are also criticizing the Danish Immigration Service that some visa applications for parents of minor Danish citizens are refused for reasons that should not be applicable in such cases. The second set of criticisms that we have against the Agency for International Recruitment and Integration, which is SIRI. So we are criticizing them that in many cases for visa applications for family members of EU citizens, the treatment of the cases are done in a similar manner to other visa application cases. This is a violation of EU rules, which clearly require that such applications should be handled through an accelerated procedure and free of charge. It's also our experience that visa applications for family members of EU citizens lead to disproportionate interviews from the immigration authorities in violation of the privacy for family life, and these interviews are carried out just to find a reason to refuse such applications. So we believe the applications are a violation of the right to family, the privacy for family life, which is enshrined in the European Union Charter for Human Rights in Article 8, I think. It's a gross violation to make disproportionate interviews for family members of EU citizens who want to visit their family members in the EU. This is supposed to be a straightforward process. It's supposed to be an accelerated process. It's supposed to be free of charge. But then SIRI and the foreign embassies are making the process unnecessarily complicated. We are criticizing SIRI that in some cases, SIRI refuses to process family unification applications submitted from abroad by family members of EU citizens living in Denmark, and they require them to get visas to Denmark before submitting the applications. This practice, in our judgment, has no legal basis and is discriminatory because family unification applications under Danish rules can be submitted from abroad. We are criticizing SIRI also that sometimes they carry out interviews for EU citizens and their family members, especially their spouses, to ascertain if their marriages were that of convenience or not. So a marriage of convenience is like an arranged marriage. In the course of the interviews, questions violating EU rules as well as the privacy of the parties concerned are asked to the couples. These we think are not okay, and we are criticizing SIRI for doing that. We are also criticizing SIRI for excessive time they use to make decisions for related to applications for cases to be reopened in violation of the standard practice and guidelines, like I indicated above when I was presenting the criticism against the Danish Immigration Service. So it's exactly the same scenario, that applications for case reopening for cases to be reopened are handled for excessively long periods of time in violation of what we consider to be the standard practice, which in our judgment should be a period of a month. Siri sometimes, in our judgment, abuses its competence and makes decisions on paternity issues for which they have no competence. Competence for paternity issues is given to the agency of family law or the family rights wholesale. So in our experience for some EU cases for which family members, especially children of EU citizens who apply for family reunification with your parents and step-parents in Denmark, become complicated and paternity issues arise, and then Siri on its own accord makes decision in relation to paternity issues, which we think is not correct because they don't have the competence to do that. They should refer paternity issues to the agency for family law. We also criticize Siri in that there's a couple of cases in which Siri does not give the parties the right to be heard. It's the parts hearing thing again before making decisions. So it's a similar criticism that we made against the Danish Immigration Service, and this is a gross violation of the Danish Administration Act. We also think that Siri is violating the EU treaty and the right to free movement for third country family members of EU citizens who have ongoing application cases. So if, for example, the spouse of an EU citizen applied for a residence card in Denmark, and then the spouse requests for a re-entry permit to travel around the EU and maybe out of the EU and to return to Denmark, then this should be a straightforward process. But then Siri, in our experience, will request for so many requests for things like the flight reservation, the reasons why they have to travel, and stuff like that. In our judgment, this is a violation of the rights to free movement for the EU citizen and their family members under the EU treaty, because then it should be a straightforward process for them to be able to travel all over the EU territory at any time they want, and to travel out of the EU and return to the EU territory at any particular point in time. It shouldn't be a complicated process for them to be given re-entry permit. So we think this is a violation of the rights to free movement under the EU treaty. We also have these criticisms against the Immigration Appeals Board. In our judgment, we think the Immigration Appeals Board handles appeal cases related to EU citizens and their family members like other immigration cases. And they use excessive case processing times for such cases. We think that this is not correct, and that cases related to EU citizens and their family members should be given preferential treatment and should be handled within a reasonable period of time. We are also criticizing the Immigration Appeals Board that sometimes they send letters by post, especially to us when we have our official e-box, instead of using the more efficient e-box. So we think it should be mandatory for them to send letters by e-box to those who have access to the e-box. There's no reason why sometimes we receive letters by post and sometimes we receive letters via the e-box. Sometimes also the Danish Immigration Appeals Board fails to uphold exceptional grounds uh, according to which some of those with appeal cases should be allowed to be in Denmark during the appeal process. So what we mean by this is that sometimes, even though exceptional grounds in our judgment are clearly applicable, the Danish Immigration Board still requests those submitting the appeal in some of those cases to leave Denmark. This we think should be reviewed, and things that should be considered as exceptional cases should be clearly spelled out so that such mistakes should not be made in the future. We also have our final criticism is against the Agency for Family Law, and I think this is very unique. The Agency for Family Law is also what we refer to in Danish as Familieretshuset. Familieretshuset came officially started existing not long ago, and it took over most of the activities carried out by the defunct Statsforvaltningen, and most especially they are now handling family law issues related to marriages and custody for children and things like that. So the Agency for Family Law made very nice promises that applications for marriage licenses, so you need to get a license and authorization to get married in Denmark before you get married at one of the municipalities or the commune. So it's the Familieretshuset that is handling all the applications for licenses to get married in Denmark. And when you go to their website, you see very nice promises, a very nice promise that your case can be handled within 5 days. So it means within a period of a week or two, it's possible to get married in Denmark. In our judgment, it might be possible for some people, but for many cases, especially those involving third country nationals who want to get married to either EU citizens or other people who have some kind of residence in Europe, it's a nightmare to get married, to apply to get the marriage license in Denmark. And we have some applications that have been ongoing for several months without any lawful justification. So we think this excessive case processing time is unjustifiable. It's unjustifiable that an application for license to get married should take several months when there's a comprehensive list of documents that are supposed to be submitted, and then there's a standard application form that can be completed online. So we don't see any justification why the applications in such cases take several months. So the excuses they usually give is that they have many cases, and then I'm just like, why then do you make a promise that you can handle cases in 5 days? Either they employ more people or they change the promise that they have put online that they can handle cases in 5 days. So we think that is not okay, that what is happening at the Familieretshuset in relation to applications for marriage licenses is not okay. In our judgment, we also think that Familieretshuset is exceeding its competence in many cases uh, in relation to the competencies that have been given to it by under the Danish Marriage Act. We say so because sometimes we wonder if a familiar rat who said is an immigration agency or is an agency that that grants authorization for people to get married in Denmark. Because then, in the course of the application to get the license to get married in Denmark, in some cases, then after submitting the application, familiar who say will request for documents and information that are inexistent anywhere amongst the requirements. And then the reason for them requesting for such documents is, according to them, to ascertain if a potential marriage can be a marriage of convenience. So like I said, a marriage of convenience is like an arranged marriage, or what we call in Danish pro forma. So in the course of this, Siri will request for private personal information and documents from applicants just to ascertain if a planned marriage is a marriage of convenience or not. So what I don't understand is why the Agency for Family Law should take the pains to carry out activities that should be reserved to immigration authorities, because then usually issues of marriages of convenience are apparent when people apply for residence permits to live in one country or the other, not when people want to apply to get married. So it's a waste of time, because then people can get married anywhere in the world. It's not only in Denmark that people can get married. People can get married in Sweden, people can get married in Afghanistan, people can get married in Iraq, people can get married in Nigeria. Everywhere in the world people can get married. And in most cases, those marriages will be recognized in Denmark. So why is it that the Agency for Family Law is wasting a lot of time and resources to ascertain whether a potential marriage is a marriage of convenience? We think this approach is wrong, because then that is the responsibility of the immigration authorities. Because then, if you want to live in Denmark, you only have one choice: to make the application for some kind of residence permit in Denmark. In that case, the Danish immigration authorities have the competence to assess if the marriage is one of convenience or not, and not the Agency for Family Law. Because then the fact that people want to get married in Denmark does not mean that they are planning to make any kind of application in Denmark. So to my mind, this practice from the Agency for Family Law is the waste of resources and a waste of time, and we also think that they are incompetent to do so. So we are criticizing them for this, and we hope that they will focus on what on the competencies that they have to assess the application for marriages, if they are correct, and then to assess whether potential marriages are marriages of convenience or not. So, ladies and gentlemen, it's been a while going through this complex presentation with many complex issues, and we are going to stop the first part of the presentation at this point, and we promise you that you will have the second part of the presentation in due course. So make sure you like our Facebook page, or you follow our Facebook page to get current information on immigration issues, and also to follow our subsequent video broadcasts. And we are promising that the subsequent broadcast will be live, And we hope that at the end of the presentation, we might answer some calls, and we'll be able to respond to a couple of questions. Thank you very much for listening and watching this presentation. Bye.